What are we going to talk about?
Well, what's stealthing? I mean, we just had a recent case. Where,
you had a recent case. That was great.
We're a firm. We're a team. Where a client was found not guilty after a trial of stealthing, which is the term for
NCCR. I just learned that today from one of our associates.
What does that mean?
I thought
Sounds like a Star Trek.
I thought it was a Star Trek reference, or a
like
new
NC 007 or something,
or a new civil rights movement. But no, it's not. It's non-consensual condom removal.
Okay, so stealthing is what?
Well, it's when you remove your condom when you're having relations. That sounds a bit awkward. Do they still say having relations in this day and age?
I use that. So it's removing a condom during the course of intercourse.
Where the complainant thought it would remain on.
Yeah, and these are typically cases where it's an agreement for sexual intercourse, where the
terms of engagement
where the terms are very clear that a condom must be worn.
Right.
And if during the course of the sexual interaction, the condom is removed
intentionally.
The term for it, what do you call it, the colloquial term or whatever, is stealthing.
Stealthing. I had never heard that.
Yeah, so like a stealth fighter.
Well, it's also like Star Trek. Stealth mode.
Or stealth
cloaking shield, whatever they do when they Klingons cloak.
I remember those things.
Remember those things?
I do. Quite fondly. There's a new Star Trek coming out.
Is there? I did not know that.
Anyways, it's a serious allegation, and this was an interesting case. And we'll talk about it, I think, just from the perspective of how to deal with evidence that surrounds the type of case like this, and then also what really happened in this case and how there can be misperceptions and how you have to try and deal with it. But just from an analytical standpoint, I think we got to first lay out, the legal framework of this. So we've called it, the term by stealthing, but it's removal of a condom, and it's a situation where the parties have agreed intercourse will only occur if the male party is wearing a condom.
And it would not otherwise happen.
And if it were not for that, there was no consent to sexual intercourse. So what's the leading case on this area of the law as to whether removal of a condom during the course or not wearing it, having promised to wear it, results in a sex assault? What's the leading case?
So that's Kirkpatrick from our Supreme Court of Canada. It's a 2022 judgment, July 29th, 2022. And it's different because there was another case dealing with a similar issue, but it involved deception. There was
a case before called Hutchinson,
yeah,
which was decided also by the Supreme Court of Canada, and it was argued in this appeal, but it was distinguished, and we had actually spoke about this on a podcast quite a while ago, I think over a year ago, where we talked about that the definition of sexual assault had changed as a result of the decision of Kirkpatrick, which is the Supreme Court of Canada decision, because the Supreme Court of Canada essentially decided in this case that that the non-use or removal of a condom during sexual intercourse amounts to a sexual assault, not by way of the pathway through fraud.
Right. That's not a fraudulent thing. It's not like you're doing it without the other party knowing.
So in just to put the framework so that we're all operating on the same basis. So in Kirkpatrick, the complainant evidence was that she made it very clear that she would only agree to have sexual intercourse with him if he wore a condom.
Yeah, everything was up front.
During their second episode of intercourse, Kirkpatrick did not wear a condom. The complainant only realized that this had occurred when he ejaculated inside her. It went to appeal, and ultimately the Supreme Court of Canada decided that the Hutchinson decision did not govern their analysis. And it said condom use when it was a condition of the complainant's consent formed part of the sexual activity in question under Section 273.1 of the Criminal Code, which defines sexual activity.
Right.
So that's important, and it's a bit of a review of what we spoke about before. So when consent to intercourse was conditioned on condom use, the only analytical framework consistent with the text, context, and purpose of the prohibition against sexual assault was that there was no agreement to the physical act of intercourse without a condom. So what they've said is, if a person removes a condom or does not wear one when there's specific agreement that a condom must be worn, that is a sexual assault within the definition of what constitutes a sexual assault.
Right. What happened in your case, the one that you won?
Well, the client was acquitted. So
I know.
So this was a case where there were a lot of facts, but the main issue was the parties had agreed to sexual intercourse.
Right.
He had always known what her boundaries were and that a condom had to be worn during any type of intercourse. There was some debate whether she had agreed to sexual intercourse, and this came out in cross-examination and other material which undermined her reliability. One of the reasons it led to an acquittal, but leaving that aside.
Yeah, there was other stuff. Yeah.
The argument was that she had believed her position was on the bed facing the wall. He was behind her in that position, and they were having vaginal intercourse, and then it moved to another form of intercourse. And during that course of time, she felt that he had removed himself once or twice. And during that time, she thought he had removed the condom, continued that form of intercourse, and then when it had finished, she turned around and said, you know, what's happened? Were you wearing a condom? Did you remove your condom? To which she alleged that he had shown her an intact condom, and then eventually admitted to saying, I removed it, I thought you'd like it, and then later on showed her a condom that in fact had been in two pieces, saying that it had broken. So she said, you're lying, you sabotaged it after intercourse, and you had removed it and called police, and he was charged. That was the sort of the matrix of the allegations. And our client's evidence was that, in fact, he had been dating her for 2 years. They had a short hiatus and then had resumed their relationship. And from messages that we had that we cross-examined her on, which was rather pertinent at the time, was that, in fact, she was very interested in resuming the relationship. And they were talking about not just dating, but essentially getting married and what it was to have a family, and their, you know, career and academic endeavors aligned, and lots of, you know, discussion you might have about wanting to further your relationship. And he said that we consensually started to have intimate contact, that in fact she had straddled him and started kissing him, and et cetera, et cetera. So he said, I knew her boundaries, I'd used a condom. I asked her if she wanted to have vaginal intercourse. She agreed. Eventually, in cross-examination, she admitted that he asked, and she agreed. And then he had asked for anal intercourse, and she had agreed.
With conditions.
She disputed that in cross-examination, and there was evidence that I could impeach her with, which led, again, also ultimately to factor into her credibility and reliability. But what he said was, he had asked, and of course he understood very clearly that any form of intercourse had to be with a condom. And during the course of the intercourse, sorry for saying that. And during the course of it,
let me think that one through.
As he was removing himself after he had ejaculated, he had noticed that the condom had split. He started to panic because he knew what her boundaries were and that she was particularly concerned about disease and her health. And he started to freak out, and he pulled out, and the condom essentially was broken, and he didn't know what to say, and she turns around, and he's trying to cover himself up, and he's holding it, and he's freaking out, and she's asking these questions, and he said eventually that it broke, and she called him a liar, and got angry at him and accused of having sex without a condom, and goes downstairs, and then he said he pursued her to try and explain and tried to show her the condom. She wasn't interested. Eventually he took it upstairs, left it on his desk, where ultimately when the police were called, they had gone in with a crime scene group, and they had taken photographs and examined the room, which included photographing the condom and then eventually photographing it various positions. which had semen inside it and emanating from the condom, and it was indeed in two pieces. And they had also obtained the packaging. So there was a string of condoms. They were all attached. The wrapper was still attached to the other wrappers, but there's only one open. There was no discarded condoms or other wrappers at all in his apartment. So they did a thorough search. And ultimately, you know, she was testifying that it was quite clear that she could not see what was going on. She was only going on the basis of what she allegedly felt, and again, what her feelings were physically was limited given the type of intercourse that they were having. And you know, at the end of the day, there were issues, significant issues with her evidence that we were able to contradict with respect to messages we had, as well as an email she sent, and then cross-examination about the condom. She said that the condom was in 3 pieces.
I was going to say, wasn't there something about it being cut out?
Yeah, she said it was in 3 pieces, and he clearly cut it with a scissor, and she drew it out apparently for the police. And when I cross-examined her and I put all the crime scene photos to her, she said, that's not the condom. That's not the condom because it was in 2 pieces. And it was just, you know, either she was in such a heightened state of distress that she was mistaken. Right. But in trial, it really came, I mean, I asked her, I mean, could you be mistaken? Could you be this? No, that's not it. That's not the condom. Really? And the police testified, and so it was very clear there was no possibility of another condom.
Of a switched condom,
and there was no timing for him to try and do that. No. And then when you saw the condom in the pictures, it was quite clear that it wasn't cut with a scissor. It looked like a failure of it physically, and there was semen emanating from the actual condom. Hence, that was the condom used. So ultimately, there was an acquittal, and he was believed on his evidence about that it had broken what he had said. And the judge said there was, you know, some challenges with his evidence as well, but it could be explained to him being frightened at the time. That's sort of the gist of the case. Right. We'll get into it a little bit more because I think it's important to talk about for this episode, you know, what it means to try and combat an allegation like this. But it is a challenging type of case because of the very nature that it's one of those things that condom failure is really not common.
So I'm just looking at the Supreme Court of Canada's decision in Kirkpatrick, and I'm just going to read something to you so you can explain.
I can't guarantee you.
I know that it's the time of day, but here, let me read this and tell me what does this translate into? Conditioning agreement to sexual touching on condom use goes to the heart of the specific physical activity in question and the existence or non-existence of subjective consent. And here's the question part. And there's no need to resort to the doctrine of fraud and its stringent legal requirements.
Yeah. So
what is that?
So the Supreme Court of Canada in Kirkpatrick came to the conclusion, after examining, that there's 2 pathways to come to a conclusion that there was a criminal
sexual
offense
assault,
committed. Okay. One of the pathways was that the failure to wear a condom is part of the actus reus, so it's part of the act of sexual assault, so it's one of the constituent elements. Right. And the other was through the Hutchinson method, which was to resort to fraud, that it was vitiating consent. And the Hutchinson decision was where, in fact, the accused had used a condom that, like the Kirkpatrick case, was one where the complainant had specifically said sexual intercourse is contingent or conditional upon wearing a condom. But for some reason, the accused in that case decided to sabotage it. But in that instance, the court had decided that the sabotage was an act of deception, which came within the fraud provisions, which would then vitiate the consent.
Right. And why do they call it stringent? That it's more stringent.
I'm not sure. So I think if I remember correctly, we did not disagree with the decision in Kirkpatrick because ultimately it was found beyond a reasonable doubt that, in fact, he had removed the condom contrary to their conditions, and therefore was a sexual assault. We disagreed with the pathway because I did not see and I think you and Diana, if you both were on the podcast, I don't remember. I think it was the three of us, that we thought that this was also an act of deception.
Okay.
And that act of deception then would vitiate consent. I saw it as no different than sabotage. Because you promise something and you don't do it and you remove the condom, to me that's an act of deception. It's a fraudulent issue. I did not see it necessary nor logical to have it as part of an element of the definition or the elements of sexual assault. So I had a hard time understanding that. I mean, the appellant in this case, and Kirkpatrick, argued that the court was actually bound by the fraud pathway based on Hutchinson. But clearly the Supreme Court, and I think it's Madam Justice Martin who did the majority reasons, that that it does not govern all future cases where a condom is not used.
So right now there's two pathways, right? Conceivably. So the one pathway one is everything's negotiated up front, everyone agrees, but it doesn't happen, right?
Right.
Pathway two is there's no real agreement. The complainant assumes it's being used.
Well, then you will have an argument as to whether that was actually a condition of sexual intercourse.
Right. Well, right. Yeah.
So just to be clear, because it's look, I have to reread this decision. So in Hutchinson, the court addressed how the law should approach consent when an accused intentionally sabotaged the condom he was required to use during intercourse. In that case, the complainant and the accused were in a rather sort of rocky long-term relationship. She repeatedly told him that she did not want to get pregnant and therefore insisted on a condom. Hutchinson instead wanted to get her pregnant, hoping their relationship could continue. While the complainant consented to sexual intercourse with a condom, he had, unbeknownst to her, poked holes in it, rendering it ineffective as a means of birth control. So the majority held that the complainant's consent had been vitiated by fraud under Section 265 sub 3 of the Criminal Code, while the majority held that she had not agreed to the sexual activity in question under Section 273.1. These are the sections that govern elements and then the fraud provisions. So, with respect to consent.
Right. So I get why that's a more stringent test, obviously.
Actually, to help me, can you give me that?
Which one do you want?
The black
black thing?
The black thingy. Because everybody may have a question about this.
They may.
Oh, you got long arms.
Well, somewhat. There you go. We got the Bible, the criminal law Bible.
Yeah, so
it's getting bigger every year.
Yeah, it's going to get bigger, trust me, when the conservatives come in.
Yeah, probably.
I find it a challenging issue. And I think it's important how we frame it, but I've lost the battle, so it doesn't really matter what I say.
What do you mean? You won the trial.
Well, the client was acquitted, but I don't look at it. I think he was appropriately acquitted because he was telling the truth, frankly.
You're going to need the reading glasses. You know that.
Nah, I'm fine.
You're still good? Okay, I couldn't do that.
So this is important. So the meaning of consent is a very important definition. And under the Criminal Code, under Section 265, consent for the purpose of this section is defined where there is no consent, where the complainant submits or does not resist by reason of an application of force. So in other words, if there's an application of force without consent, it's not consent.
Right.
There's threats or fear of application of force to the complainant or other person, no consent. Fraud or the exercise of authority. So that's where you get to 265 sub 3, which is the definition of consent. So the one that's relevant to us is sub C, which is fraud, if you obtain consent under fraud.
Right.
Okay? So the sabotage, they were saying, was a very circumscribed, specific set of facts which wasn't forming part of the element of what is a sexual assault. It was vitiating consent through the fraud provision under Section 265.
Which is...
Okay, yeah, no,
Yeah.
I don't have a problem with that.
I know.
But in this case, where the condom use is a condition of the complaint's consent to sexual activity, it will form part of the sexual activity in question, and the consent analysis under Section 273.1. If the actus reus is established, the focus will shift to the mens rea. If the accused is mistaken and has not been reckless or willfully blind to the complaint's consent and has taken reasonable steps to ascertain the consent, they may be able to put forward a defense of mens rea stage on the analysis. Okay,
Seems more black and white.
so that is
This
a
path.
situation where if the accused can establish that there may be some mistake as to what the condition was and took reasonable steps to ascertain what the conditions were, there may be a defense as to honest mistaken belief. But leaving that aside, the court clearly found and distinguished from Hutchinson there were condom use as a condition of the complaint's consent to the sexual activity. It forms part of the sexual activity in question. Period. That's how they ground the liability.
And that's, as I said, very black and white. No confusion there.
Hopefully everybody understands that. But so that's the analysis. So how do you deal with that then in practical purposes? In a lot of the cases, it's going to be fairly evident as to what the set of facts are, I think. Ours was unique in the sense that there was a failure.
A unique failure.
A
Those
unique
are
failure
rare.
of the condom. And if you actually do the research...
It's rare, right?
It is rare. It's not unknown to happen. It doesn't have to be a condom which is necessarily,
Expired
old or
or
expired.
old. Right. They do have the warnings, right?
They do have the warnings. They have a high rate of reliability.
Right.
But
Life
from time to
happens.
time, it happens.
Right.
And so, in a case like this where the condom was readily available for the police to photograph and observe and do an analysis, and then from what were very good pictures that you could see where you could have even an expert look at it, it was very clear, even to the untrained eye, that this wasn't cut with a scissor. Right. That
Where would he have time to cut it with it?
Well, he might have had time when he went upstairs, but the bigger issue was when you looked at the breakage itself,
Right.
It wasn't consistent with what would be use of a scissor with any type of straight edge or any sort of consistency in the cutting. It was frayed. Oh. There was true fraying.
So that's huge.
In the breakage. And how do you explain then also the semen? Right. Because her argument, and this I find it important, if you take the complainant's evidence, which again, she's surmising certain things happened because she didn't have a view.
Right,
obviously.
and it was dark, right? That was part of the
And
evidence.
the room was dark, but there might have been some light, but it was dark. But she's surmising what may have happened based upon her feeling at the time of the physicality of what's going on.
Right.
The evidence itself was clear that he had said he ejaculated. She had said she thought he ejaculated. And her evidence relied essentially on one main pillar, that he had removed himself, took off the condom, and then continued intercourse for a period of time. So let's be clear about this. The story then was reliant upon one very basic factor, as I call it, a pillar, that in fact intercourse continued and he had ejaculated, therefore, without a condom on.
Right.
Well, there's two problems with that. One, the condom that in fact the police had photographed, and good for them. They came in, they got there really quick, arrested him, secured the scene, photographed the entire room, photographed the condom. Eventually, when they took it back to the police station, they took it to a secure location and properly separated it, photographed it from various different angles. You could see that there was fraying. You could see that there was a liquid emanating from it that was clearly semen. Had they actually tested for it, it would have tested as semen, I have no doubt. And so that, went against her narrative that, in fact, he had removed the condom and continued intercourse and then ejaculated. So that was a problem. And number two was when you just examined it, and again, to the untrained eye, you could see the fraying was not consistent
with scissors.
with scissors. So there is a real problem with that for the Crown to achieve any conviction. And the pictures were independent evidence corroborative of the accused evidence when he testified as to exactly what happened. And he went through it in some detail, and he was totally believable about his panic at the time, knowing what her boundaries were and her fear. So, you know, when that oddness happens, and if you have a case similar to this, you know, it's really important for the police to do an investigation and to have that evidence available.
Was the Crown alleging the scissor cuts?
I mean, the Crown did a very good job of trying not to completely, they kind of straddled two theories, but you could not escape forget about what the Crown was arguing. You couldn't escape the complainant's evidence.
Yeah, and the physical evidence.
So that was a real problem, and his testimony was very good. And so you had independent evidence corroborative of it, and the police, again, to their credit, checked the wastebaskets in the room. There was no other condom. You know, of course, one could be flushed, but this one had the semen in it.
Right, yeah.
And they checked the wrappers. They found the wrappers in a specific location where he described that he actually had them. They checked. There was only one that was torn, still connected to the other wrappers. So thank God the police did this level of an investigation, which really helped.
Could have been easy to be sloppy on this one.
Could have just arrested and not really do a photo, obtain anything, and then you'd be left to trying to make an explanation. Right. And of course, you know, you could still argue that the police should have done this, but it's a much more difficult situation. Right. But what remains then is, you know, for these rare cases, if you don't have one which is occasioned by a break, and in other cases it may be fairly obvious if they have the condom and the police examine it, that it may match the description of what the complainant says. So in which case, you're going to have a very hard time defending it. But the removal issue, really, in my opinion, comes down to simply about what the agreement was.
Right. That's why I said this is pretty black and white, isn't it? It's pretty straightforward.
Yeah, I mean, I think, you know, I just wanted, you know, this is one of those cases where the analysis of whether you got to a conviction through vitiation by fraud or whether it's part of the actus reus of the sexual assault really didn't matter, because the devil's in the details. I still don't understand why we needed to change the definition of sexual assault in Kirkpatrick, but whatever. Yeah. If you're in another case where there is, you know, removal of a condom, and you would have evidence of ejaculate inside of the complainant, especially if they do a sexual assault kit, you know, really your only other avenue is, why was that condom removed? Right. And the explanation would only have to be, well, what was the agreement, and was there actually an agreement for it?
Right. Number one, yeah.
And if there's a discarded condom which is found, that's going to be a problem for the accused to explain. You have to sort of go into great detail about what that agreement is. And two, if there's not a condom found, you know, the accused can testify that, in fact, you know, there was no agreement about using a condom, and we had agreed on, you know,
whatever, yeah, then
some sort of method to prevent,
he says,
that there's pregnancy.
Yeah.
But I find that these are very challenging cases, because I think it's always an issue when, especially if you have parties who are not in a long-term relationship, that if there is the lack of a condom during intercourse, really the accused is in an onus position, even though there's supposed to be no onus.
Right.
You know, you're kind of in an onus position to having to deal with why.
Right.
Why was there unprotected sex?
Right.
So that was an interesting sort of set of facts we had, which caused me to start to think about, and we had an inquiry about a case that was similar, which sort of sparked my interest in talking about this on a podcast, about how you deal with this stealthing issue.
What do you mean?
You know, it's one of those areas of sexual assault where I think it's really, it's a much more challenging area, sort of aspect of sexual assault to defend.
How so?
Again, like, I think the facts speak for themselves.
Starting to sound like Yoda, aren't they?
That's right.
How so, young Jedi?
I just find it, you know, where there's sex without a condom. Again, if these parties are not ones that have been in a long-term relationship, you're not planning on having a family, all that other stuff. This is the main use of contraception and protection from, you know, communicable diseases. You're going to have the onus on you, whether you want it or not. It's going to be on you.
Yeah, it's going to shift on you.
And then I don't think it's as simply as easy as saying it's a he said, she said about what the agreement is, because it seems logical. And now that common sense is back in fashion, one might determine that, yeah, use of a condom is common sense. It would make perfect sense that you would agree to that. Right. And that would be a premise upon which you can have it. So I think it's a challenging area. And it was just one of these unique cases where we had an actual breakage, where there was actual a failure, which was strongly supported by the independent evidence that the police had produced.
I don't think you've ever had a case like that, have you? No,
Never.
No, I don't recall.
This was the first in our practice, and I again, we were very fortunate. The police did a thorough investigation. They got there within a short period of time. The accused had remained downstairs. Our client was downstairs with the complainant, so he hadn't run off anywhere. He just simply got pants on and waited. To his credit, he just waited.
That was excellent.
And the police arrived, arrested him, put him aside, went upstairs, and did their business, and did a thorough investigation, which was extremely helpful to corroborating the accused testimony. And even if we didn't have certain elements based in messages and other things to cross-examine the complainant to contradict her, which raised reliability and credibility issues, I still think it would have been sufficient for an acquittal here, because his evidence,
physical evidence
was totally believable.
Yeah, totally believable.
And that in those pictures, and it just goes to show, I think what I find most stark about this is how investigation is so important for both sides of the equation.
Right.
Both for, wanting to secure conviction if you're the Crown.
Exculpatory evidence.
And exculpatory evidence.
Right.
How many cases do you have where, we talk about this so often, where the police are actually out at this crime scene investigating if it's something that's relatively short in time, that's reported, like within moments?
Rare. That they actually show up fast and
then, arrest and start to investigate.
Oh, arrest is the default.
No, but investigate, look at the crime scene and stuff.
Virtually almost none.
Yeah, again, it's...
We talk about this a lot. There's hardly any investigation.
I've had a few cases where they go out to investigate potential witnesses sometimes. We've had that one case where they went out, our client was there, they went into the house, executed a search warrant within hours. It was a drugging case, so they'd grabbed glasses and bottles and looked at the sink and did all sorts of stuff. But it's so rare, and it just goes to show that, you may not realize, but a search of the scene, if there's a complaint within a few moments to a few hours afterward, is so incredibly important. Seizing bedding, doing all sorts of things. And that just happens so rarely.
I know. Well, high volume, right? We always talk about that too. A lot of these cases, no time, lack of resources. Shouldn't be that way.
I'm not clear also when we look at Kirkpatrick and Hutchinson that, it really, as much as it bothered me maybe about a year ago, whether you get to the sexual assault through the fraud pathway or through the definition of sexual assault, I don't think it matters that much. No. Because the analysis comes down essentially to what the facts are.
Each of these cases are very fact-based.
But, again, if you're dealing with this, it's one of those cases where you've got to be very careful about what evidence is available and how do you use that evidence to support your client's defense narrative. And in this case, we were very fortunate.
And if it's not available, ask for it.
Well, yeah, for anybody who's in a situation, or a lawyer who's watching this and you're young and just starting out, you've got to have very detailed disclosure requests
right away,
asking for everything.
The next day.
At the end of the day, even if they don't do it, sometimes you can put a police officer in the stand and ask, why was there not a search? Why was this not obtained? Why was this not done? Why was this not done? And they'll just give whatever excuses, but at least you'll have before the trier of fact
a lot of missing stuff.
A lot of missing opportunity to get evidence. But judges, sometimes judges will say, well, so what? I think that's quite effective in front of a jury. Sometimes judges will go, well, the absence of evidence isn't going to necessarily guide the analysis.
But jurors are a different story.
Anyways, I hope this was interesting. It's one of those cases where, as my own forensic review, I'm looking at these pictures going, that's not hang on, give me a condom. Let me cut it. Nope, that's not the way it's going to look like,
That doesn't look like skizzers.
Doesn't look like it. And it also goes to show, I'll say this sort of in closing, there are situations where a complainant may not be out and out. We don't always have to vilify or say somebody's a fabricator. No. I think in this case, the person's panic so overwhelmed her that her perception of what she thought had happened and then what she observed afterward were completely skewed by her panic.
Right. No, that makes sense.
And it may have been honest that she thought it was in 3 pieces and thought it was scissors, and then thought that she felt this, but it was totally skewed. And that's an important aspect that we got to remember. As much as the Crown wants to argue, naturally there will be inconsistencies, because during the traumatic experience of a sexual assault, a complainant will get certain things wrong or will make errors in giving their evidence. That also cuts to the benefit of an accused, because sometimes they can just be honestly mistaken or come to believe a set of facts simply because of their emotional state, which isn't true. And this was a stark example of, in fact, the complainant of what she perceived and saw wasn't true.
Right.
And it may have just been simply a factor of extreme emotional panic, which skewed her perception during and after the event.
Yeah.
Pillow talk.
Oh,
No, it's
can't
too
reach.
far.
It's too far. We're too old to
I got
reach.
it.
You got it. Okay.
Stop it. I'm not that old.
No, me. I'm too old to reach.
If
over.
you like our episode or a podcast, please like, share, and subscribe, and send comments, because we are getting so many comments, and people email. I say this every episode, and they ask a question about an area of law or about a topic or a scenario, and that sparks in us an interest to do a podcast on it.
Yes,
so thank you
please.
very much. And
Yes.
I had to share this because this was my first instance of stealthing of something which had broken, where you rarely describe it. So it was interesting to us.
Yeah.
And we got a chance to review these decisions. So thank you for watching, and see you later. Have a good night.
Thank you.